and I don't know how much they appreciate the difference between validity and infringement, and that those two branches.
Well, you know how
we're going to get started.
It's a big deal to patent attorneys, but
We're going to get started. I am Artie Rye. I am the faculty director of the Duke Law Center for Innovation and Policy. The executive director of our center, Steve Merrill, is in the front over here. Steve, could you please stand up? Steve also has the honor of having written the National Academy's report that basically recommended the creation of the PTAB. So we have a bit of a Duke lineage because Steve wrote the National Academy's report. Former Chief Judge James Smith is a Duke Law alum and was the first PTAB Chief Judge. So we are very honored to be holding this event on whether administrative review of granted patents at the PTAB is constitutional. So welcome to all of you. This event is being webcast, so as a consequence, when we have audience participation, which I hope to have a lot of, I will point to you, and you will get a microphone so that your voice can be heard on the webcast. We understand that we have a lot of people listening in on the webcast, so it's really quite important that the webcast turn out well and that the recording turn out well as well. So that's one logistical item. The second logistical item is that we have the first panel here and the panel 2 speakers up here. Because things will be interactive, panel 2 speakers will occasionally be asked if they want to make a comment on anything that was said by panel 1. They will get, if you will, first dibs. But then I will also turn it over to the audience to see if there's anyone who is has a burning desire to make a comment, at which point you will get a microphone. So those are logistics. The restrooms are outside. There's a sign if you need to use the restrooms. We will have the first panel focus on some of the nuts and bolts details of the PTAB. What would happen if the PTAB were declared unconstitutional? What might happen if the PTAB is deemed constitutional, but there are other issues that are still circulating regarding the PTAB. So the first panel, all of the bios are in your program. Extremely distinguished group of litigators and scholars. I won't have time to go through their incredibly rich bios, so just look in their bios. The first panel will focus on those issues primarily. Panel 2 has a number of very distinguished constitutional law scholars and litigators, including the former Solicitor General of the United States, Don Verrilli. So we are very excited about the second panel as well. That will really dig deep into the Article 3 issues, dig deep into why the Supreme Court seems to be so interested in patents, and assorted questions relating to what happens if the PTAB is deemed unconstitutional. Okay. Each speaker on panel 1 and on panel 2 will get 5 to 7 minutes. Steve Merrill, whom I just introduced, will keep rigorous time because it's important in this context. And rather than have you guys get bored by having everyone speak for 5 to 7 minutes seriatim, after about 3 or 4 speakers, I'll ask some questions, ask for reactions from different panel members, and so forth. So we'll have it be very interactive, lest anyone think that we'll just have talking heads for 45 minutes or so before we start discussing robustly all the issues. James Smith is special, and he gets 10 minutes because he's going to give us a little bit of the history of what it was like to set up this institution from scratch back in the day. So James, take it away.
Thank you very much for having me. What fun. Can't imagine a more interesting topic. Who would have guessed we would be here at some point with this issue before us? Even before we get to the first set of questions from Artie as we speak, I invite you to stop me if something I say is so reprehensible you feel the need to do that. I have seen in the briefs to the court that parties sometimes quote former chief judges, and to minimize the possibility that I would say anything that might appear in a future brief, stop me ahead of time. Here's the first question I'd like to put out, and that is, what is the question? The question could seem to be, are IPRs and the other AIA trials being heard by the PTAB unconstitutional? That's certainly the question as it's presented to the court. But there's some other questions maybe we should ask as we look at this. One of those questions is whether or not our federal government, and specifically Congress, adequately funds Article III courts. My understanding is, and I haven't checked it lately, that not more than about 1% of total federal expenditure goes to the federal courts. 1% for one of the three branches of government. That might seem strange, might seem wrong. Question next would be, is it relevant? I think it is highly relevant. Let's imagine that we're in the time period between 2009 and 2011, and that instead of spending devoting 1% of the federal budget to the courts, our government devoted, say, 1.5%, 2%, maybe 3% to the federal courts. Might they look very different than they do now? Imagine, for example, that the District of Delaware has 12 judges, and that Congress has acted to fill all 12 of the spots they would have allotted. You might say, Delaware? Be serious. It's a strip of land. Or is it? It's also the home to perhaps more corporate bodies, more corporate persons than any other state in the country, possibly. Certainly it's in the top 2 or 3, and as a result, many disputes find their home in a court in Delaware. Are there enough judges to hear those cases and to hear, for example, patent cases? Again, the question of how is this at all relevant? Well, in that time period, if patent cases, including those cases in which validity is at issue, are being heard so as to provide quick and affordable decisions, is there then less pressure to modify the Board of Patent Appeals and Interferences so that it might also hear questions of patentability in trials as part of its jurisdiction? I contend that a good bit of the momentum that drove the legislation that left us with the PTAB results from a court system, an Article III court system, that is not fully empowered financially and by appointment to carry on the work that then we have looked to some other body to do, some other tribunal to undertake. That's not really a question of constitutionality or not constitutionality. It's the question or the issue of an underlying problem that seeks resolution, which then leaves us to tackle the issue as to whether the resolution arrived upon by Congress is a constitutional resolution. Let me take you back to what really was the situation in 2011 and what we had to do in the agency. Many people think of the PTAB, and I heard this often when I was there, thought of the tribunal, the board, as that new board. Not a new board at all. The fact of the matter is the board actually derives from a history starting in 1861. the first appointed individuals who carried out the responsibilities inherited by the board were appointed by Abraham Lincoln. In fact, he did it in the same weeks in which he was deciding how to tackle that little problem at Fort Sumter. Appointed 3 individuals to carry out the work, and the board evolved with an increasing jurisdiction and examiners-in-chief and then administrative patent judges who did a substantial amount of work for the patent system long before the AIA and the additional jurisdiction of the AIA trials and the enhancement to the PTAB. What was that work? Just to make sure we have the context in which these questions arise. In 2011, the Board of Patent Appeals and Interferences had a long-established jurisdiction of hearing trials in interference proceedings, deciding priority as between inventor claimants, and it also had a substantial and more voluminous jurisdiction involving ex parte appeals, appeals arising from the examining corps where individuals didn't receive patents and thought they were done wrong by the government in not being granted those rights. In 2011, the board took in, the board already had an inventory of undecided ex parte appeals of 18,000 cases and was receiving cases at a rate of 600 more cases per month than the board was deciding, which eventually led to an ex parte inventory of 28,000 appeals to decide, 95 judges, and an embargo against any expansion of the board. And then Congress said, by the way, we're going to send you some more work. What work did they propose to send us? They proposed to send us about 360 trials per year of the IPR variety. And as you probably know, what happened is, instead of getting 30 new cases per month, the board received about 200 cases per month. I will never forget the summer in 2013. Law passed in 2011. We acceded to the jurisdiction in 2012, and then the slow buildup began. By 2013, we were sitting in the office across the river in Alexandria, watching the cases go from 30 per month to 50 per month, 100 per month, 150 per month, and then we were sitting there saying, oh my goodness, if this goes over 200 per month and we still have the ex parte jurisdiction to deal with, what are we going to do? Fortunately, at that point, and largely due to the stellar efforts of then Director Kapos, the embargo was gone, the board was expanding. We were able to cause the increase in the ex parte appeal backlog to end, to begin to bring down that jurisdiction, or rather that backlog, and establish to Congress that we were in a fighting position to handle the AIA trials. And in fact, I know at least through the time I was there, and I believe this may still be the case, the time deadlines imposed by the statute never have been missed by the PTAB, even though the law requires that the cases go the whole trial run in 360 days, which is extraordinary if you think about it. So where are we now, and what's the real question? Well, I think maybe the main question we need to address is not changed between now and as a result of this appeal to the Supreme Court and what the question was before. I mean, there is the question as it's framed, and here's my analogy for how the question is framed. I view it as a constitutional matter. This is the question. Is the PTAB repo man or auto thief? The patent is the automobile. and it has been repossessed or taken possession by someone in the night. When the owner was looking, or maybe when it was the tow truck pulled up and grabbed the patent off the street. No one likes the repo man, but the repo man is not engaged in unlawful activity. The auto thief who thinks himself empowered to take the car, but is not empowered, after he takes it, he is a thief for having undertaken unlawful activity. The Supreme Court will let us know, has the PTAB been a repo man all along? Don't like him, but you can't get rid of him. Or an auto thief, unlawful, give the car back, which raises a whole nother set of questions right there. Either way, Congress has work to do. If the proceedings are really unlawful, then Congress has to go back to the questions that drove the creation of the proceedings in the first place. Maybe more robustly funded and supported Article III courts relieve the pressure in the system. Even if the Supreme Court says the proceedings are constitutional, Congress still has work, because to the extent there is dissatisfaction with the proceedings as they are, then those dissatisfactions will not go away as a result of a congressional ruling, and Congress needs to address how the proceedings are improved.
Thank you, James. Erika.
Thank you for including me and including a voice from the PTAB practitioners bar, I guess. I am, in addition to being a partner at Finnegan and a patent litigator, I am the president-elect of the PTAB Bar Association that was formed about a year ago. We have about 900 members who practice and appear before the PTAB on a regular basis. I have, since I come to this with the perspective of someone who, since the very beginning, the very first petition, have spent the last 5 years nearly every day appearing at the PTAB. When I am not on a phone call with the board, I am filing papers with the board, or I am arguing before the board, like many of the members of our association and the practitioners who are appearing at the PTAB. When I'm not doing that, I'm across the river talking to the Federal Circuit about the PTAB, and that is what I have done for 5 years, like many others. I share that because it's important not to think about what I've done for 5 years, but what I did for 15 years before that, which was essentially the same thing. I was going to the patent office, I was challenging invalid patents, I was defending patents that were valid and talking to the Federal Circuit about them. I think I give this example because I think for a lot of the practitioners who are appearing at the PTAB who have experience with that body and with those procedures, we have to be careful not to allow form to rule substance. And while we are in this particular regime right now at the board, I spent 15 years before arguing before the board. To your point, they were called something different, and maybe it was coming from a re-examination rather than a PTAB trial. It comes to mind one of the comments we received from the office when we formed the PTAB Bar Association, which was, we hope you're a full PTAB Bar Association, meaning the entirety of the board, not simply the trials section, and that in fact 2/3 of the judges on the PTAB have appellate jurisdiction and work on the appeals coming from the examination corps and appeals coming out of ex parte re-examinations. And so I think it's important for us, and I'm fascinated by the details and anxious to hear everyone's thoughts on the PTAB itself, but I think it's important for us to remember the substance of why the PTAB was created and indeed why the patent system was created. I think it's important in any of these big cases to really remember the whole reason we have a patent system, and for me, the balance that was created when we established a patent system, that it is not simply for the patent owners. It is not all about the inventors. We certainly want to encourage them to not only make their great ideas, but also to share them so that others can come up with even greater ideas. And if that's the case, the patent system is there to benefit more than simply the patent owners. It is certainly about the public and those who need to understand the patent rights. And the best way that I can think of to get there, in my experience, is to improve the quality of our patents and our patent system. And so at the end of the day, I hope that we can allow the substance to shine through, even as we talk about the form of how the current challenge is done. And so to the question, the overall question of what happens if the PTAB is unconstitutional, we just do this in a different form. And as we did before, as we would continue, these substantive issues are important. They are part of our very economy, and they're not going to go away, even if the forum does. To that second question, though, I think in addition to let's not become form over substance, my other point is let's give the PTAB some time. Almost as soon as we started these trials, reporters would ask me, do we need to go back to Congress? What are the problems? Is this something that needs a legislative fix? The estoppel provisions, the amendments provisions, whatever the specific details of these trials, is it time to fix it? And it always seemed very hasty to me. And even today, after 5 years, I still think we're pretty early in the process. It's really been fascinating to many of us to watch the entire legislative process of our country unfold. I mean, to see a new law written by Congress, to see an agency interpret it, issue regulations, actually begin implementing it, and then to allow the courts to come in and review and correct where needed. That process takes time, and I have seen specific examples where it is working. Where the goals that Congress set out when it wrote the AIA, things like improving patent quality, reducing patent litigation, you're not going to find a patent litigator who would say that patent litigation has increased since the AIA. We've seen significant reductions in some of the things that were specifically targeted. I'll give you one specific example of a part of the law that doesn't get as much coverage, but it was one of the things Congress said when it implemented AIA, and that is the data treasury cases, which were very famous patents in the banking industry that were targeted many different times by attempted legislation. They were patents that covered the imaging of checks, so the electronic processing of your checks at your bank. And the data treasury a company had 2 patents, and they ended up $300 or $400 million in licensing fees from all of the top 25 banks in the US. And they were continuing to enforce these patents. And Congress called them out specifically and created the CBM procedure, some say, for those 2 patents, but for other patents like them, troubling business method patents. Not all business method patents, in my view, are wrong or bad, but the Patent Office needed some tool to revisit those patents. And in that case, the CBMs were filed, the patents were invalidated at the Patent Office and affirmed at the Federal Circuit. And there are many other business method cases like that, where that targeted procedure has given the Patent Office tools that it didn't have before. And there are other improvements as well outside of the business method arena. Judge Smith mentioned the timing and the fact that these are such a limited procedure, the trial procedure being completed within a year. The Patent Office says that it has never missed the deadline. Some of us may quibble in certain cases, but that's the official word. But in any event, the fact that it's short allows litigators to go to the district courts and explain that this will be done more quickly. And it is a huge improvement over the re-exam practice where it could take years and years, and you would never see the litigation stayed. So you would end up with this multiple tracks of litigation. So we've seen that force a huge reduction in the costs of patent litigation on both sides of the V. So I think there are some concrete improvements that the board and its trials are better than what we had before on balance. Not perfect. There are many changes still to be made. I think some are underway. The Federal Circuit has an en banc case on the motions to amend that we're all curious what's taking them so long. But it's working, and I think we need to have some patience to allow the time to play out. So.
Thank you. So I have a question for the group, including panel 2. So Erika and to some extent James also talk about whether this change to the PTAB is a change of simply a form rather than of substance, because the re-exams also revoked patents. I think that's perhaps what you're getting at. So if the Supreme Court finds inter partes review unconstitutional, do they have to find ex parte re-examination? And, well, I guess inter partes re-exam doesn't exist anymore, but would they have to find ex parte re-exam unconstitutional as well, because it's a very technical form difference? Anyone want to take that on?
I'm happy. So I think the way the question's framed by oil states and its amici in this specific case, I think there's no way, on their argument, you can't distinguish ex parte re-exam from the PTAB proceedings, from inter partes review. With that said, I think under the Article 3 case law, at least that portion of the case law that takes a more functional approach to the Article 3 question, you could actually distinguish ex parte re-exam from inter partes review, simply in that, I don't personally believe this, but that the argument that inter partes review is more of an encroachment into what courts do, whereas ex parte re-exam is more of a continuation of the administrative process. So as the question's been framed to the court by the petitioner and its amici, I think they rise or fall together, but I think there are ways to distinguish them, at least under the functional strand of the Supreme Court's Article 3 case law.
Does anyone else want to take a swipe at that question?
Yes, you have to look at how they're different at the end of the day. I completely agree with that. Like if you take a more functional perspective on the Article 3 question, re-examinations are very different from IPRs and PTAB proceedings. Right? They can be deemed constitutional, maybe for the same reason that original patent examination is constitutional if it is. Right? They allow a much more practical right to amend. Conceptually, re-examinations are rights-granting proceedings. Right? The patent gets examined. There are opportunities to amend. In the end, you get a certificate that gives you new claims. At the end of the day, you can appeal. You can appeal through 2 layers, unlike IPR. And IPR then, in comparison, is a very different kind of proceeding, much more an adjudication, where at least by one narrative, 2 parties come in, they present their case to an adjudicator, and the adjudicator decides who's right. You know, it looks very different in that respect.
Don Burley. Oh, can we get a microphone to Don quickly? Yes.
So I don't know. It seems to me that there's at the bottom of this, there's kind of a metaphysical quality to the Article 3 challenge that the patent process might be a public right until the patent's issued, and then its character changes, and it's out there, and it's a private right, and its adjudication is treated just like any other private right. And I don't know why that logic wouldn't apply in both circumstances. If this claim's going to prevail with respect to IPRs, I think some version of that is going to have to gain a majority support in the court. I don't think it's going to be about function. It's going to be about the sort of metaphysical character of the thing.
Great. Well, we've already got some interesting discussion going. I will let Adam have the last word. Adam, could somebody get a microphone to Adam? And then we will move on to Rob. As promised, we're getting robust engagement already.
Very quickly, I was just going to say, Hans and Greg characterizes their discussion as functional, but the way you actually describe the distinctions, Hans, were structural and substantive in the very nature of the organization. And so I think you can get the result through either a more formalist approach or a functionalist approach.
And just to clarify, there's 2 kind of strands in the Supreme Court's Article 3 precedent. One is a more formalist distinction between public rights and private rights, and more is a more functionalist balancing test that's seen in Thomas and Shore, and that's what I was referencing.
Great. Excellent. Rob?
So in the spirit of expanding the conversation to include other views, let me give you a couple of disclaimers. First of all, I'm in about 170 of these proceedings, and I'm in probably more for patent owners than anybody in the country. But I've seen it from both sides, and my firm has the 2nd largest number of these of any firm in the world. So if these were to go away, this would be bad for us. But I think we need to step back. I think back to 1988 when Bob Armitage and I were both elevated to the AIPLA board. And I was thinking back to the famous big names of the patent bar back then, Tom Arnold, Tom Schmegel, Bob Benson, Jan Jansen, all of the greats of the patent bar of the 80s. And the idea that we would be here today would have been horrifying to them, because the idea was that we needed strong, robust, predictable property rights. That's what they used to talk about at the board all the time. And even the ex parte re-exam was considered with askance by a lot of the big corporate patent owners. So then I think to 2006, when Sedona first asked me in their patent litigation conference to speak on the subject of this thing called inter-party re-exam. And Terry McMahon asked me to do that. And it was the first time Sedona in their patent litigation conference had dealt with these procedures, the PTO, these very seldom used procedures at the time. And of course, we were right in the middle of the patent troll boom that made many large law firms very rich, to the consternation, frankly, of their clients. So the question is this faster, cheaper, and better? For who? It's clearly a fabulous proceeding for anyone accused falsely of infringement. And I use that very pointedly. If you're on the receiving end of a patent today, this is the best thing ever happened. But if you're a patent owner, you have to ask two questions. Number one, was the statute as it was actually written what was sold to the public? And I would tell you, having been involved in this as a private citizen, it didn't come out exactly the way it was represented to many of us. A lot of things happened at the last minute in Congress behind closed doors that created things that we were not told about, not asked about, and frankly, have made major issues for why we're here today. The second problem is how it was implemented at the PTO. The PTO had a one-year statutory deadline that they had to observe, and they have. More power to them. But many people, we all know this, I'm not telling you anything you don't know, many people say, is the system fair? Is it really faster, cheaper, and better for patent owners? And I would say no. It's not faster. It adds 3 years. You have to win everything if you're the patent owner, every last thing, in 2 tribunals. You go to the Federal Circuit twice at a minimum. Is it cheaper? No, it's not cheaper because nobody settles anymore, regardless of the value of your patents. And is it better? Well, why are there different claim construction rules, different evidentiary rules? Your ability to defend your rights at the PTO are much more limited than if you're in a district court, regardless of whether you're before a jury or not. So these are the issues that you're going to hear about from some of the other speakers. But we have to put this in context. Is this constitutional or not? Let's say it is. Has that solved the problem? No. So I predict that regardless of whether or not the Supreme Court finds this to be unconstitutional, which I don't think it will myself, this is far from over. We will be back here. We will be back here on this very topic. Thank you.
Thank God. So I can't resist a follow-up question, Rob. When you say it's far from over, will we be back here on other constitutional challenges, or will we be back here on all the nuts and bolts of fixing it through Congress, through just a...
Well, I think the Stronger Patents Act is an indicator of how much industry is up in arms about this. And it doesn't have anything to do with the size of the patent owner or their business model or their technology. So I think the Stronger Patent Act is a litmus test of what's going to happen in the Congress. And of course, there are people on the other side of that who are going to kill that law if they have anything to say with it, and even push further back on patent rights. So the legislative fight is going to be big. And I think we're going to see a new head of the PTO, and many people in the patent world are wondering, what is Andre going to do?
Thank you.
Assuming he's confirmed.
Paul.
Good assumption, though. I think he'll be confirmed. Good. I'm delighted to be here. I'm not sure why I'm here. I'm not a constitutional lawyer. I have no light to shed on what the Supreme Court is going to do in the oil states case. I'm fascinated by it, but I don't know what's going to happen. Now a series of disclaimers. I wrote an amicus brief for the Intellectual Property Owners Association in oil states in support of neither party, but I'm certainly not here speaking on behalf of IPO. I'm certainly not here speaking on behalf of my firm, and I have clients squarely on both sides of this issue. I am basically a litigator and have been for more than 30 years. I've tried cases all over the country, including the ITC. And I have pharma clients, that think the IPR is the worst thing to ever happen to their business. And I think they're right. And I have high-tech clients who think that IPR is the best thing to ever happen to their corporate bottom line. It's been a great tool for them against patent troll litigation. And I think they're right, too. So I'm definitely not speaking on behalf of either camp of clients or any particular position other than my own. And I look at this issue, and especially what oil states could do to the patent system, and I am torn. I'm schizophrenic. On the one hand, I think that a finding that the IPR system is unconstitutional is going to be greatly disruptive to the patent system. And it may be a disruption that the system can recover from. In fact, it would recover from. But in the short term, things will be upset. And I don't think that's the best thing for the patent system. And it's a system that I love dearly. On the other hand, there's a little devil on the other shoulder that says, whoa, would this be really cool if the oil states decision in the Supreme Court came down and held inter partes review unconstitutional. And it's not a hypothetical question for me. I'm in discussion with clients already about that what if scenario. What if we have IPRs thrown out? And what would I do representing in that situation patent owners? It'll depend on whether there's true finality already in the decision against assuming my client's patent has been held unpatentable by the PTAB. But in many cases, the wheels of justice grind very slowly, and then it's not final yet. It's up on appeal before the Federal Circuit. Maybe there's a petition for cert that's still wending its way in front of the Supreme Court. So let's start with the it's not quite final yet situation. Well, if oil states dumps the whole IPR system, a system that held my client's patent unpatentable, I'm going to be looking, I think, for four things. First, I want my damn patent back. Okay? I want my patent reinstated. I want my car back, to use Judge Smith's very, very good analogy. I'm going to steal that. That's really good. Second,
he has a patent on that.
He probably does, or at least a trademark. Maybe scandalous, though, so we'll see how that goes.
About to lose in an IPR.
Second, my patent was under this very dark cloud. It was held unpatentable for X period of time. I want that term back, and don't tell me I just want my pre-existing term back. I already got that back. Thank you. I want that extra period, that year where the world thought my patent was unpatentable, added to the end. It may be problematic, but I'm still going to ask for it. Third, I want just compensation. I mean, this was an unlawful taking by the government, and I want any lost revenue. I have been heard in the marketplace. We are going to be trotting economic experts in to tote up that damage. I've had loss to reputation because of this terrible unjustified cloud over my patent estate. Okay, that sounds like pain and suffering, I know, but well, why not? Let's see how far that can be pushed. And then the fourth thing that I will ask for, I assume that the patent was involved in some type of enforcement proceeding, and I immediately want that ramped up again, no matter what the status may have been. And even if I've had a final adjudication all the way through the Federal Circuit, any possibility of certiorari has passed, I'm still going to try. If the patent is of any value to my client, and in the pharma space, you can guarantee it is. Now, what are the roadblocks? Well, obviously, if it is a final decision, that's going to be a huge one, right? The doctrine of finality is a big deal, rightfully so. The law favors final resolutions and not reopening Pandora's box. But you took my client's land. You took their property. I don't care if it was a final decision or not. A part of me says, I get that back. I get that back. Maybe damages will be dicier in that situation, but I think it's still worth a try. Waiver, I think, also is going to be a potential issue that anybody in this hypothetical situation trying to put the Humpty Dumpty back together again, having held their patent unpatentable. Did I actually need to preserve my position that the AIA was unconstitutional in order to get my client's patent back? I would hope not. But you can imagine that will be an argument, and I think precious few people, until the Supreme Court actually took up oil states on cert, were routinely alleging unconstitutionality of the inter partes procedure in their papers. So that would just be an enormous amount of fun to go down that route, and would have, I think, a great deal of Schadenfreude joy for patent owners that had their patents held unpatentable in what they view, right or wrong, as an unfair stacked deck procedure. But probably that would be too much fun for outside litigators like myself. But hey, a guy can dream.
All right. Well, thank you, Paul. Hans?
Very well.
Perhaps you've gotten some ideas from Paul?
I did hear a couple of themes that I might pick up on. So a few words, just where I'm coming from, because my job and the people I serve have taken a powerful hold over the only way I'm capable of thinking about this case. I work for the Biotechnology Industry Organization. So my guys are companies that view themselves as singularly patent dependent, IP dependent in the way they can build, plan, and fund their businesses. Right? They're all patent holders, innovators, and that. So about this case, to us, when cert was granted, and we had long conversations with our member companies, these drug and biotech, agricultural, pharma companies, all across the map, there was something provocative about the case, clearly, right? And the provocation that was sensed, I clearly got that from my members, was there's nothing special about patents as a predicate for this case and for defending the attack on the constitutionality. The first defenders who stepped in, of course we knew the government would defend the constitutionality of patents. But they stepped in and they necessarily premised their defense on this notion that there's actually nothing really special about patents. They're quote, they're mere public rights. They're not, like other things that can get regulated and decided by administrative agencies. And it proceeded from there, right? So that clearly is, I think, to many, and I saw it throughout the briefing, it was not in a way just provocative for my own members, it was a problem for a lot of stakeholders who wrote briefs. Like all the briefs talked about the status of patents as private or public rights and dedicated large amounts of space to it. So here we are, right? Are patents just like other things, or are they a little bit special? So it was pointed out to me by my patent lawyer colleagues inside companies that the IP clause in the Constitution is actually the first pronouncement in the Constitution of an individual right. There's no question that that's what it is. When you read the clause, it talks about securing to inventors their rights. Right? It was adopted before the Bill of Rights was written. Right? Now, what exactly to make of that isn't really clear, but surely the framers must, it seems to us, meant something special with that. They must have intended something important by calling it out. Well, it surely must mean that patents are more than simple governmental gratuities to be awarded and reclaimed just like the government can award social security and reclaim it when it's been overpaid, as the government argues in its brief. Right? So we start from that. Patents certainly are important to us. The Patent Act describes patents as having the attributes of personal property. This was mentioned earlier. Right? And to us, they have plenty such attributes. They can be bought, sold, or gifted. You can devise them in a will. You can inherit them. You can lease them or mortgage them. You can even lose them in divorce. Right? So they look and quack a lot like property. Right? And from the very beginning, disputes, as we learned, disputes over patents from 1790 on, disputes over patents were committed to the federal courts. For almost 200 years, it apparently didn't occur to anyone that they could just be put back into a hearing and could be revoked by a hearing officer, right? And I think to us that suggests that this whole discussion about patents as mere public rights that can be decided by administrative agencies is a notion of relatively recent vintage. It doesn't have, at least from where we stand, the deep roots in U.S. law and the Constitution, patents as mere public rights to be revoked by executive agencies. I think that's a new phenomenon. I don't think it has deep historic roots. Leaning on a public rights theory of patents, the PTAB today then is positioning itself as the preeminent and final decider of which patents are valid in this country and which ones are not. Right? The PTAB confidently claims judicial deference to, even unreviewability sometimes, of its decisions and practices. The PTAB has unwisely been permitted to operate under lower standards of proof than federal courts, with no presumption of validity and no presumption that the original grant of the patent was administratively correct. It has secured for itself a claim construction standard that is different. We heard this from the federal courts. And it's in the process of doing the same for its indefiniteness standard under Section 112. So this disparity in legal standards has many effects. We think those effects almost universally work against patentees. And more importantly, the application of different standards systematically allow the PTAB to reach outcomes that are different from the district courts, even to nullify them if it deems that necessary. The impact on patent law is profound. The advent of the PTAB, in our view, has created a big shift of power away from the judiciary to the PTO, and it has also invested a very great amount of uncertainty into the patent system, at least for patent-owning, investment-heavy businesses. Now, in their long discussions about the oil states case, our member companies didn't intuitively focus on the Seventh Amendment argument or the jury trial question. Our own corporate litigation experience is different. We bring a lot of litigation, but it's usually bench trials. We seek, not so much monetary damages. It's often equitable relief. It's injunctions. But our member companies did gravitate towards the Third Amendment question. The Article 3 aspect comes from this kind of thinking. Our companies are very sensitive to parallel adjudication in district court and the PTAB, and that is a common experience in our industry. Defendants in our industry, patent defendants, litigation defendants, accused infringers in district court litigation will typically litigate the patent for about a year in district court. They will take what they have learned. After about a year, they will take that to the PTAB and they will start a second rail litigation. They do this as a hedge against the outcome of the district court litigation. If the district court upholds the patent, they still have a reasonable chance that the PTAB will strike it down. And even if the PTAB and the district court both agree that the patent is valid, defendants have not one, but two chances at an appeal and get the result overturned under different standards of judicial review when it goes up to the Federal Circuit. That, to us, is the quintessential second bite at the apple. Right? And I'm going to leave it there because that's really what's been driving our notion of the case. It's the Article 3 question. We see a lot of encroachment. Our member companies have to see only a few examples of where a patent was in fact litigated in district court, was upheld as not invalid in district court, and that was affirmed by the Federal Circuit. And then the PTAB takes the same patent on the same evidence and strikes it down, pointing to its authority of using different legal standards. And when that gets appealed to the Federal Circuit says that's correct too. Right? You can tell this to lawyers, but to business decision makers whose minds weren't warped by law school, that's a very, very difficult proposition to tell, right? Boss, here's what happened, and they go, what do you mean? One said it's invalid, the other said it's not invalid. One of them's got to be wrong, right? And we have to say, no, both are right under the law, right? This may make sense under the law, but for business decision makers, I tell you seriously, in all seriousness, this is not a possible way of running a business. So this case has us greatly concerned. We don't know if much good will come of it, But I hope to have given you at least our perspective.
Great. Does anyone want to respond to any of the comments that have been made, particularly maybe Hans's very energetic statement?
I certainly, since I already have a mic, I'll jump in. One, I think, again, setting the constitutional question aside in a way, which is to say, presuming that the answer came to be that the proceedings are not unlawful, I think there are corrections that should be made. I have three that are in the Stronger Act. It has other things in it, but here are the three that I think the way things have moved already suggests these things should be done if the tribunal has the authority to act in these proceedings. Clear and convincing instead of probability. Same claim construction as district court, but then remove even the theoretical possibility of an amendment, which really is the anchor to using the broadest reasonable construction. And then you have a proceeding which is much more like district court, which then maybe makes it more attackable on the constitutional ground. But so I think those are things that should happen even if the proceedings survive, because they're part of what drive the dissatisfaction with the proceedings. All that assumes, though, that the proceedings survive. With regard to the question of whether they survive, I would like to suggest that there may be some things worth more exploration in the areas Hans has suggested we look at. If we look at the Constitution, Section 1, Article 1, Clause 8, I don't think it's proper to say, see, there it is, the property existed, and now it's not being treated properly under the Constitution. I think a robust reading of what is there, and there's a lot around it that helps us understand what's there. We have to acknowledge, for example, the correspondence between Thomas Jefferson and James Madison, which essentially said, at least the Jefferson side of the correspondence, none of these people own anything. They have no right. And giving them any right here, let's start with the proposition that it ain't a good idea. But then let's see where we might, the government, give them something to the benefit of the public under a set of standards by which we deem what we give them to have been worth the giving. So maybe that means there's a right just like you owned a property interest in land or an automobile, maybe, but I think it's very important we need to give a full reading to the context before we reach a conclusion as to what was being handed to the patent owner when the bequest is made.
All right.
John.
Okay, yeah, so I just want to reinforce that point. I mean, Article 1, Section 8, Clause 8 is a grant of power to Congress. It's not a grant of any personal rights. It's an empowerment of Congress to grant exclusive rights for a public purpose, to promote the progress of science and the useful arts. So without the 1790 Patent Act, there are no federal patent rights unless there are private bills, which people did petition for from Congress for individual grants of patents. So I think that just is a point that should be kept clear. The reason it's put in there is partly because of a background hostility in the common law, and as reflected in the statute of monopolies, which that language largely tracks, to state-granted monopolies, which Madison was certainly concerned about. A second point, this really goes more to Paul than Hans, is just the note on what could happen. Well, the Supreme Court could take away some of your fund. If the Supreme Court follows what it did in Northern Pipeline when it found unconstitutional a broad grant of jurisdiction to the bankruptcy courts, it could say, it is equally plain, as it said there, that retroactive application would not further the operation of our holding and would surely visit substantial injustice and hardship upon those litigants who relied upon the Act's vesting of jurisdiction and the bankruptcy courts in that case here on the PTAB. We hold, therefore, that our decision today shall apply only prospectively. And then they stayed their mandate for a few months to allow Congress to act. Given our current Congress, they might need to stay it for several years. But that could be one way some of your fun is taken away.
Okay, so we have a lot of people who want to respond. Adam and Hans, and then Josh in the back, and then Dimitri as well. I would suggest that you guys will all get your opportunity after Greg and Mike get their 5-minute statement. And that will be perfect because that means that we will not lack for robust discussion.
Thanks. So I want to take a little broader picture of this, because what concerns me about the impact of potential impact of oil states if oil states strikes down IPR is not so much the elimination of inter partes review or the other post-issuance trials. I mean, I think that will have a significant consequence for the patent system, as Paul's touched on. But I'm more interested in what it means for Congress's power over the patent system and Congress's power to change the patent system. So I think largely what's special about the patent system in terms of, and compared to other regulatory areas, is its history. It's been around longer, and it's been fairly static since the mid-1800s. Most of our substantive patent law doctrines developed in the mid-1800s, and they've been changed here and there by courts. Congress largely has recodified them and or kind of made little changes around the sides. The structure of our patent system largely dates to 1836, and Congress has moved appellate authority around in patent cases, but largely the structure of the patent system has been the same since 1836. And so what we have is kind of a history here, and there's a sense that anytime we depart from that historical baseline, there's something wrong about it. So the AIA probably had the two most significant departures from that historical 18th or 19th century baseline, which is moving to the first-to-file system and then the post-issuance procedures. And what was the response to both of those? Constitutional issues. Now, the constitutional issues on first-to-file kind of they were debated. It was members of Congress raised it, and then they kind of disappeared. And then obviously the post-issuance procedure constitutional issues have bubbled up all the way to the Supreme Court. And so what's concerning about it, if the Supreme Court strikes down IPR in oil states, is it's giving credence to these constitutional challenges. And the reason I say that is, at worst for IPR, it's arguable. The Article 3 case law is arguable. Now, I've written a piece saying it's not even arguable. These are clearly constitutional under Article 3. But at worst, it's arguable whether Congress had the power to create the PTAB. And for the Supreme Court to come in and say, with this arguable precedent, or even precedent that suggests it's constitutional, no, this isn't constitutional, it's really second-guessing the policy choices of Congress. So much of the arguments that we're hearing around IPR are policy arguments. That it's bad for biotech, that claim construction standards, burdens of proof, none of that has anything to do with what's protected by Article 3 or the 7th Amendment. And for a long time, the Supreme Court has repeatedly said that it's up to Congress to set the terms and conditions of the patent system, that the Constitution is permissive when it comes to patent rights, and therefore it's up to Congress to say how far patent rights should go. And they said that actually in the 19th century, they said that in the context of the structure of the patent system, the structural relationship of the patent system. Because in that time, the question was different. The question was, could executive functions be given to the judiciary? That is, could Article 3 courts even be given authority to review patent office decisions, because that was giving executive functions to the judiciary? And what the Supreme Court said was, yeah, they can. It's kind of judicial enough. And it's up to Congress to kind of decide what procedures and what structural arrangement is best for the patent system. So for the Supreme Court to reverse and strike down IPRs here is a real departure from that kind of, this is up to Congress to make these policy decisions. And I'm concerned about that in two parts. The first is, anything Congress does going forward is going to be subject to constitutional challenge. It's going to create a constitutional cloud, dark cloud, over any congressional change to the patent system, in particular, a congressional change that departs from kind of the historical 19th century baseline. And so that the mere cloud is going to stifle kind of innovation in patent law. And then my second concern is there's no real reason necessarily. There's plenty of policy arguments why we should have this a kind of a 19th century or a steady patent system and substantive doctrine from the 19th century. Because this isn't a debate between originalism and non-originalism. A lot of the arguments for the historical baseline are framed in originalist terms. And in reality, this is just a pseudo-originalism. The patent system and the concept of patent protection in 1789 looked very different than it did by 1836 or by 1850. And the Congress experimented significantly with the patent system between 1790 and 1836 and the structure of the patent system. And then things kind of just got stagnant in terms of it. And so, again, ultimately, patent rights are an intervention into the free economy. And they're a means of regulating the market economy to achieve certain public policy ends. And it's not clear to me why the substantive doctrines, why the structural arrangements that were good for the 19th century society and 19th century economy are necessarily good in the 21st century. Maybe they are. Maybe you can make the argument that, you know, patent rights have spurred the world's best economy or those types of arguments. But those are policy arguments. Those are arguments for Congress to decide. And so what I'm really worried about with this oil states case is a stifling of Congress's power over the patent system, and therefore a stifling of the ability of the patent system to adjust and adapt to a changing society and a changing technology and a changing economy.
Thanks, Greg. One follow-up question for you, and then maybe we can get some of the other comments that were going to be addressed to Hans. So is this going to create a patent silo, essentially? If your view is that if the Supreme Court holds this unconstitutional, we're going to get more patent siloing such that Congress can act in all sorts of other areas, but patents will be kind of siloed off. Is that? Yeah,
I think that's correct. That you know, it's one of the Article I powers, and we think that Congress has a lot of leeway on the Commerce Clause, or Congress has a lot of leeway in other areas under Article I, and then to kind of carve out patent law and say, no, it doesn't have that discretion, simply because Congress didn't really exercise its powers to kind of adjust the system for a long time, I don't find persuasive. Though, I mean, I think ultimately this case is probably going to be decided more based on other concerns than patent concerns, because it doesn't seem with this Supreme Court reversal is going to happen because they're concerned about the policy issues and the patent system. It seems that they're probably more concerned about other policy issues.
Great. So the reason I asked that question is because on panel 2, we're spending a lot of time discussing whether this is really a patent case. Does Congress really care that much about patents? Or is this a way of thinking about the administrative state more generally? And I think Greg's comments provide us a good inroad into that subsequent discussion. Mike, and then we'll have Adam and Hans' response, and Josh.
So let me look at it from an entirely different angle that we haven't discussed yet. I represent a lot of companies that are, you know, inventing, releasing products into the marketplace. If oil states comes down and IPRs are unconstitutional, what happens the next day? It's tempting to think that immediately you all call your patent attorney and say, I need a lot more patents. Because it just sort of seems like, well, now this second check on the quality, as some of the Federal Circuit cases have talked about, that IPR served, that's not there, so the enforcement can now continue in district court with the presumption of validity. And, you know, it's tempting to think that, and I think to some degree it might be that way in the short term, but I think when you take a closer look at it, it's going to bring a lot of attention on where is the quality set in the patent office the first time around. And frankly, right now, I think if you talk to a lot of practitioners, there's kind of understanding that the system is kind of a wide funnel There's 200,000 current numbers are that are examined every year. There's resources brought to bear on that examination, and even some of the court cases reflect that there is a need, and that's partly what Congress was addressing with IPRs, for this second check on quality. I've never really liked the second check on quality and the language sort of correcting mistakes, because I think it's more like the initial examination is a process that's set up to do an initial cut as strong as they can make it with the budget and resources available. And then it's sort of understood that certain smaller percentage of these patents are the ones that are going to go into litigation, and IPR often is brought in to address that. So on one hand, I think there are a number of practitioners who think if it is unconstitutional, well then we have a lot of great tools. In fact, sometimes I think this is the golden age of getting patents, because there's track one, there's ways to expedite. Many of the art units now in the patent office are allowing at rates higher than 80%. So if you're trying to get patents, there's a lot of tools at your disposal in many technology areas. On the other hand, if IPRs remain, do you get that same phone call? And I think that's what a lot of the panelists were talking about, where are we tuning the system right? Maybe give IPR some more time, some more reforms to tighten those boundaries. And we are seeing the emerging of markets from a freedom to operate perspective for smaller companies like software developers. People mentioned trolls and non-practicing entities. I think it's important to look at the market that patents are involved in, especially licensing. There were some business models that went around in terms of enforcing patents, and now for the last 5 years, especially with IPR coming into the mix, we're seeing a lot of models that are making it easier to indemnify other companies, making it easier to provide insurance on patent litigation. And for some of the smaller companies, these are really important, and I think they would affect those business models, because a lot of them rely on the fact that IPR is a cheaper alternative to litigation. So there's a part of me that would like to see IPR keep running, keep tuning, keep improving it. And a lot of these discussions, if we were to come back again, as Rob was suggesting, and we really look at how the patent market works and how we can make it more transparent, how we can make the pricing more effective, how we can make the actual use of patents work better, so that it isn't always you have to go to the court or you have to go to litigation to ascertain the value of your patent.
Great. So that gets in part to the question of what kinds of property rights, if they are property rights, how are they actually being used, which we could easily have another conference on, and it's a great question, Mike. I want to give Hans a chance to respond, because I think he wanted to respond to some of the comments that were made, and then Adam and Josh and Todd Dickinson. And we have a total of about 7 minutes, so you'll all have to speak very quickly.
So I'm going to try. Yes, I had two things that I just wanted to ask back on. One, John, you said, yes, the Constitution is permissive towards patents, but it doesn't require them. I think that's true, but the Constitution did call out patents. That didn't call out licensing of U.S. vessels on the high seas. They didn't call out licensing, of customs agents and other things that Congress may have been thinking about at the time. Right? So that was the only point I was making. They called it out. And, because my companies are so patent dependent, it's understandable that they want to see significance in that. I think we'd all be well served by trying to figure out whether there was something meaningful about doing that, or because otherwise, they needn't have called out patents anyway. If it's permissive, patents aren't very special. So that's my question to you. Does this mean anything, or can we just go past the fact that they're called out in the original Constitution? The second thing I wanted to react to was, the concern about, will patent law become ossified? Well, Congress's ability to do anything about patent law, will that be constrained if patents are viewed as like real, actual property rights, private rights, and the like? I think that is... Having that debate requires first a conversation about what's the status quo and who's trying to change it. Right? So I see two narratives. One narrative is patents were always public rights. Congressman, we can just do this like taxi licenses. It was never any different. And I have other people in my membership who say, well, wait a moment. Right? We think there is a change in the status quo that's about to happen. Patents were always different. They were always private rights. They were always treated like property rights. They were protected under the Fifth Amendment, and now they're just like taxi licenses. So I think until we're clear on that, I don't know, but I'm not too worried about Congress's ability to fiddle in this space. They sure have. The cloud over the patent system, this concern runs both ways. The concern about Congress not being able to do and regulate in this space is valid. The other concern is that if patents are just like taxi licenses, we're going to see them treated very differently in the future. Right? They're going to become not very special at all. They're going to become regulated. They will be granted by government, taken away if not used according to the government's desires and regulations. It's going to be very different. I think both propositions have implications. That's why I said at the end of my talk that I'm not sure much good is going to come off this case. I'd be perfectly happy if it were dismissed as improvidently granted. I really would be. Yeah.
We'll quote you on that, Hans. Adam.
Actually, given the shortness of time and others, I'll defer.
Okay. All right. Well, you're speaking on the second panel, so you can always bring in the comments. Josh or Todd?
Todd can follow my second point. And all of this goes by the way of be careful what you ask for. So it really reflects Hans' concern both about a split system, Greg's concern about policy, and Judge Smith's concern. So if the IPRs are found unconstitutional, presumably we'll be back in Congress asking them to change broadest reasonable interpretation and the presumption of validity and impose the same standards that were in the PTO on the courts. I think that would be a terrific idea. Second, if IPRs go away, we're going to go to a pre-grant opposition system with concomitant delays, and therefore I'll ask Todd to talk about how that doesn't work in other countries. And then third, and this is really more for the next panel, and this is in response to Paul's concern about preserving the constitutionality of challenges. These patents were issued expressly on Section 261's condition of other statutory provisions, including IPR. No indication Congress would have granted these patents if any of those conditions weren't met. If IPRs are unconstitutional, aren't the grants themselves unconstitutional? Therefore, doesn't this challenge wipe out the entire set of patents that currently exist? And can the Supreme Court equitably revise its judgment to preserve those patents while Congress tries to fix the problem? I'll really look forward to hearing the con law professors respond to that. And if they don't, I'll follow up. Todd.
Now we're really going to have some.
Wow.
They want to respond to that first time. You want to respond to that, or you want me to ask my question?
No.
Okay. My question gets actually to a small premise. One of the great outputs of Steve Merrill's tenure over at the STEP Board was a report on the future of the patent system, which many believe gave rise to the whole AIA in the first place. The crown jewel of that report was that we'd move to an opposition system, where in the first 9 months to a year, as Europe does, we would allow for third parties and others to come into the office and basically go through on anything, not just patents and printed publications, on anything, one-on-one as well, and have the office review what they couldn't review or didn't review when it was inside. That was thought to be the major change. All IPR was simply moving the re-exam system from one side of the house to another and cleaning up a few things that are in it. Yet lo and behold, we find in the unintended consequences, IPRs take off because of the way the board is interpreted, the way the rules ended up being written, for a variety of reasons that can change, but that's what really drove it. And yet now, PGRs, post-grants, go nowhere at all. I see my good friend Suzanne Michel over there and others, they don't commit at all, as I understand it, to filing a PGR at all. They want to wait till they're sued, which doesn't exactly seem to suit the system. So my question, I guess, is basically, someone has told me that the question only says IPRs at the Supreme Court. Will this only deal with IPRs, or will they also deal with all of the post-grant processes? And isn't there room to differentiate? And don't some of these arguments hold a lot better merit when you overturned a patent, so the parliaments went, while it was technically still with the patent office, and you had that investment and a lot of people hired and that sort of thing, while you wait to see how the market develops. I know, by the way, the Supreme Court has no shyness about, the Congress has no shyness about overturning the Supreme Court when the Supreme Court has undone something they did in the patent area. There's a number of cases, not the least of which is Mr. Duffy's case, where he took away my judicial appointments.
So this is great. Todd, you raised the question about PGRs. CBMs are going away, so we're not going to worry too much about CBMs. But PGRs that's a very interesting question. Of course, to Don's point, those are also post-grant. So if we have this metaphysical distinction between pre-grant and post-grant, all of a sudden the grant of the patent creates something really distinct as a formal matter, then maybe PGRs fall under the bus as well. But we will talk about all of those issues during the next session. Right now, I think you all deserve a break, and we'll have a 20-minute break. The panel 2 folk will have a less than 20-minute break because you'll have to come about 5 minutes early to get mic'd up. And please don't remove your mics right now. They will do it for you. Thank you.
You're